Yes, Your Honor, I believe so, although I don't have the file in my hand. Please state your name, ma'am.
Sue.
And Sue, do you live in this jurisdiction?
I do.
And Sue, did you have a baby with this bum?
I did.
Object, Your Honor.
Question withdrawn, Your Honor. Did you have a baby with this man?
I did.
And subsequent to that, was there an order put in place?
Your Honor, I object. Counsel's leading his client, the witness.
Is there a child support order for
Yes,
the
sir.
support of your child?
Yes.
And who is supposed to pay you child support?
That man over there, Tommy.
And in the last 14 months, has he, back up, how much is he supposed to pay you?
A lot.
And in the last,
Objection.
more or less than 1,000?
Less.
Okay, and so in the last 14 months, has he paid you less
Objection,
than
Your
1,000
Honor.
every month?
Your Honor, unless the state can elicit evidence of a proper child support, I ask this case be dismissed.
The event is going to be taken under advisement, subject to the state to do so.
Thank you so much, Your Honor.
Subsequent to the birth of the child, the state of Missouri had a hearing and child support was set for the support of the child. Is that correct?
Yes.
And that order was subsequently docketed in this circuit court of this jurisdiction. Is that correct?
Objection. This witness doesn't know the meaning of docketed.
The Honor asks you to take judicial notice of your own file.
Permission to point near the witness.
The court's going to take judicial notice, however you may vote out.
Thank you, Your Honor. Ma'am,
Sir.
explain the meaning of docketed.
It's put in the file by the court as a record of the proceeding.
Any more questions? You may proceed, Mr. Pierce.
Thank you, Your Honor. And how much, in fact, was that order per month?
$565.
And ma'am, has this bum paid you $560?
Your Honor, I would ask the court to admonish counsel
Has
to
the
refer to
defendant-
my client as either his name or the defendant.
Has the defendant paid you?
The defendant has not paid a dime.
And how long?
14 months.
Now, has the defendant, that's cash payments, through the system, you got nothing from the state, is that correct?
He has not paid anything, through the system or otherwise.
Has he paid your rent?
He's not paid my rent.
Objection. It's irrelevant whether or not he's paid rent.
Your Honor, statute.
Overruled.
Thank you, Your Honor. Has he purchased food for your
Just a
home?
minute, Mr. Pierce. I want to, just for the audience. Now, you all may not believe this, but if you don't, you can check with my wife. I kind of like to talk sometimes. But I do have an important point to make. You know, quite frankly, I don't give a damn how much the child support order was. It makes no difference to me. It makes no difference to the law. If you'll read in the court files, of which I've taken judicial notice because they're not here, the actual charge, it does not say he's charged with a misdemeanor crime of non-support in failing to pay his court-ordered support. It does not say that. Because the criminal law doesn't care. The criminal law does care if he has that legal obligation to pay. But the amount that some court ordered or that some technician ordered, I don't care. The statute says it's against the law to fail to pay a reasonable amount. And the statute does not define that word reasonable. So there's been a lot of fussing here on both sides about something that really doesn't amount to a damn.
That never really happens, though.
Yeah. It's the first time you've been in front of me. Now, with that aside, and but I thought it was important you all to know that. Mr. Pierce, you may continue.
Thank you, Your Honor. And has the defendant provided food for your family, for your child and yourself? Or
No.
for your child, primarily?
No,
Has he paid your electric bill?
No.
Has he paid the water bill?
no,
Has he in any other way provided support for this child?
no.
No further questions of this witness, Your Honor.
Mr. Penguin, you may.
Thank you, Your Honor. Have you been eating?
Obviously.
Object, Your Honor.
Yes.
Water's
Objection,
been
Your Honor,
paid,
it's not relevant.
utilities been paid, all these things that you claim my client hasn't paid, you've received.
Your
as
Honor,
support
I
of
would
it.
object to this line of questioning. It has no
You haven't been
relevance.
denied that, your child hasn't been denied that. Has he or
Now,
has
wait
he?
a minute. Objection is sustained. Whether or not it was provided by another party is not material to this case. She could be real married to Bill Gates. It doesn't matter to this case, Mr. Penguin. You may now proceed. I hope you have a better understanding of the law.
May I make an offer of proof, Your Honor?
You may.
You've received all this money, just not from him, correct?
Objection, Your Honor. No relevance.
Overruled.
This is
It's
an offer of proof.
I apologize.
It's not
I
coming
didn't hear
in
you.
for the truth of the matter. It's coming in as a matter of offer of proof.
Ma'am,
Yes.
concludes my offer of proof. I renew my objection. I understand the court's ruling. I'll move on, Judge.
The court's ruling will continue to be overruled, and you may now continue.
Thank you. You have not let my client see his son for 3 years.
Objection, Your Honor. No
That's not
relevance to
correct.
this.
Wait just a minute. What grounds?
The issue of visitation is not relevant in the matter of criminal child support.
Your Honor, may I respond?
You may.
When child support is set, the issue of visitation and access to the child is very relevant. In fact, it's to be considered on line 11 of Form 14 when setting child support. Since Your Honor made the statement to the court earlier that we don't care about amounts, it's just whether or not we have appropriate, reasonable support paid, I think I can acquire this witness as to whether or not she has allowed him reasonable access to this child.
Your Honor, we renew my objection. It's not
Your
relevant.
objection sustained.
May I continue, Your Honor?
You may.
Now, you have not told my client, you've not asked my client, hey, have you? No, you have not. You've not made that demand, have you?
I have not made the demand.
You've gone through all those people at that what's it called, your buddies over there? That division, that child support. You've asked someone's child support to make demand. You haven't personally made a demand, have you?
I do not need to make a demand as there is
Thank
a
you.
court
Your
order
Honor, I
out of
have no
state.
further questions. That concludes my cross-examination of this witness.
Remainder of the answer will be stricken. Redirect.
No redirect, Your Honor. Petitioner
All
would
right.
call,
You have any further witnesses?
yeah, say we call Tommy to testify.
Oh, no. Sit down. Your Honor, Mr. Pierce is well aware of the Constitution of the United States of America.
As am I.
Your Honor, those are not Mr. Pingleton's
Just,
rights. Those
just a
are
minute.
defendant's rights.
As am I. Go ahead, Mr. Singleton.
Yes, thank you, Your Honor. Have a seat. He cannot testify against himself. He cannot be compelled to testify against himself. in a
He
criminal
hasn't been
case.
asked a question yet. You've been called to stand, rise, and raise your right hand.
Your Honor, permission to counsel with my client.
You may.
Don't say a word.
You will respond to that. You will respond to that.
You can answer that.
Have a seat. Mr. Pierce.
Thank you, Your Honor. Please state your name, sir. Your Honor, I would ask the court to compel the witness to testify.
Your Honor,
Your request is denied. Mr. Pierce.
Sir, are you here under subpoena of this court?
You may answer that question.
Your Honor, I'd ask you to direct the witness to testify.
objection. He's invoking his constitutional right not to
Your Honor, there's
testify.
been nothing asked of him that would have anything to do with his...
Whether or not he's under subpoena from this court will not, regardless of the answer, will not incriminate him. You're instructed to answer the question.
Your Honor, I take great exception to that rule.
Mr. Fingerman, the court will listen to you.
he does not have to answer any questions asking him whether or not they are incriminating. In fact, whether or not they're incriminating is not relevant for purposes of invoking your constitutional rights in this country, Your Honor.
My goodness, Mr. Fingerman, it's one of the first and few intelligent things I've ever heard you say. Your objection is sustained, Mr. Fingerman.
Say rest, Your Honor.
Wait just a minute. You want to cross-examine your client, Mr. Fingerman?
Oh, the door just went open.
No, Your Honor.
Good move, Mr. Fingerman. You may step down.
Your Honor, defense moves for judgment of acquittal. The state has failed to prove its case. Have a seat, young man.
You care to elaborate or not? It's up to you.
Your Honor, with all due respect, it should be obvious.
Your Honor, the
I've
state,
never heard that particular legal reason given before, but
Your Honor, the state has provided uncontroverted evidence and has proven its case beyond a reasonable doubt. We're now asking you to find the defendant guilty and lock him up.
anything further, Mr. Fingerman?
Your Honor, may I be permitted to present a defense? Do I get to call witnesses?
Are you going to reopen?
You haven't asked me if I want to present my evidence, Your Honor. The state rested. I move for judgment of dismissal.
You're correct. You're correct. You may call a witness.
I call Tommy.
Mr. Whatever the hell your name is. I remind you, you're still under oath. I also like to remind you of your constitutional right not to answer any questions, including any questions from this idiot that may ask you something.
Tommy, having been so advised by Judge Shortridge, are you willing to answer some questions under oath here today?
Yes.
State your name for the court.
Good
please.
answer, Mr. Weasley. Oh, I'm sorry, Tommy.
State your name for the court, please.
Tommy.
And do you know the complainant in this action?
Yes.
How do you know her?
Well.
You know her well?
Yes.
Very good. You admit that you had a child with her, is that correct?
Yes.
Now, did you all discuss having a baby before? Was it a planned pregnancy you had with her?
Objection to relevance.
Your Honor, he has to plan to pay, he gets to plan to have a baby.
I'll let you proceed a little bit, but you're gonna have to tie that in or I'll go back and sustain the objection.
I want to hear where it goes. I'm
I don't want to hear where it's going to, Mr. Fingerman.
Yes, sir. Did you plan to have a child with her?
No.
Did you plan that in your budget to support that child?
No.
So you didn't plan to reasonably support that child?
No.
I want to move on to another area quickly.
Amen.
Do you know the amount of the arrearage that these people have asserted that you owe her for past due child support?
No.
You know they're claiming that you're in arrears.
Yes.
Is that painful?
Yes.
Are you able to pay that, sir?
No.
Are you able to pay other expenses?
Barely.
Barely. Your Honor, I have no further questions.
Cross-examine, Mr. Pierce.
Where do you live, sir?
Here in Columbia.
You have a house?
Yes.
Pay rent?
Yes.
Pay utilities?
Yes.
Buy groceries?
Yes.
Drink beer? I know you smoke cigars. I saw you packing one around. Yes. So your testimony here today is that you can support yourself and your chosen lifestyle, but you can't support your child. Is that correct?
Objection, Your Honor, misstates the witness testimony. I believe he testified he buys cheap grocery, drinks PBR.
Just a minute, BDR stands for beer, Mr. Pierce. Objection's overruled. You may continue, Mr. Pierce.
You understand there's an order for you support this child, right?
Yes.
And